it's a really good panel. It's a tough act to follow. So I think I'll do my best to try and maintain, because this is based on a paper that I wrote years ago, and only recently I revisited it a bit, and it's quite a theoretical paper. Most of it is about Hegel, but what I'll do is I'll spare you from talking about Hegel, yet another dead white man too much, and I'll try and put it in. Do you like Hegel? Ah, good. So I'll try and put. Well, I'll talk a little bit about Hegel, but I'll try to put that more in context with the discussion. Right? So I'd like to start actually from where the last presentation finished. So there is this interesting argument by Gunther Jacobs, this idea that you can see two types of criminal law, enemy and citizen criminal law, and contemporary criminal law looks mostly acts like enemy criminal law. And I'd like to start by saying I don't like this distinction. I think it's very problematic for two reasons. First, in my head, there is no citizen criminal law. This doesn't really exist. This is an ideal in the mind of many jurists, but the subject of criminal law is never a citizen, or never treated as a citizen. It's mostly, at best, if we want to use that really the favorite place of criminal law scholars, but which actually represents a tiny part of the criminal justice process, which is the trial. So if we really idealize that moment of the trial, even there, the subject of criminal law is at best a conditional citizen. So citizen criminal law is an ideal, very nice ideal, but doesn't really exist. And therefore, enemy criminal law is an oxymoron, right? Criminal law, the criminal part already denotes hostility, right? So in this paper I recently co-authored with a colleague from sociology department at Warwick, called Why Punishment Pleases. Part of our main argument is that there's this intrinsic aspect in punishment that tries to generate an abstract idea of solidarity and community through hostility. So it wants to bring us together by putting us against others, right? So criminal law is always enemy criminal law, in my at least potentially, right? At the very best, the criminal law is asking its subject, who are you? Are you an enemy? To what extent are you an enemy? How dangerous are you? Right? And so the main point, or the main critique why I say citizen criminal law doesn't really exist, is because, well, one way in which I can try and construct this argument is by trying to take seriously this idea, what would a citizen criminal law look like? And in this paper, I interact with the work of this philosopher called Anthony Duff, which I think is one of the most sophisticated accounts of what's involved in this ideal of citizen criminal law. And for him, citizen criminal law would need to be a communicative process. So at the core of the idea of citizenship, of respect for the subject of criminal law, is this notion of communication. So the criminal law should communicate, should dialogue, and with its subject. And in need to do so, it needs to be a reciprocal engagement. And at the core of this idea of reciprocity is the notion of recognition. So the criminal law can be communicative as long as it recognizes its subject as a rational agent, as a citizen, as a member of the community with whom we want to communicate. But obviously, in his own theory, he himself admits that his idea of communication, although he really wants to contrast it with what he calls a problematic idea of expression, there's this notion that criminal law expresses something, expresses a moral message, symbolism, etc. He says, no, expression is too one-sided. We need to seek to promote communication. But then, as the deeper we get into his description, the more we notice that this idea of communication doesn't really live up to the expectations that he creates when he talks about recognition, reciprocity, etc. Because this communication with the subject already starts from a very specific judgment that this person is being accused of doing something wrong. Right? So the crime, there's no discussion, no negotiation as to the nature of the crime. There's no opening for the criminal, for the defendant, to try and explain what he did or she did, what she did. It's only an idea. The communication there is a very limited, has a very limited space of trying to explain him or herself, oh, I was defending myself, or I was acting under duress, or I didn't really intend to do what I was doing, but this is really shallow, right? That's why Duff himself concedes that what's happening in the criminal trial, in the criminal process, is at best forceful moral communication. And I'm like, well, forceful moral, that really isn't communication, right? There's no reciprocity there, right? We are not really talking about people dialoguing on equal footing, right? And in order to try and go to the core of what's wrong or problematic with this idea of communication, I rely on this notion of recognition, and then that's why I go back to Hegel, because Hegel provides what I think is the most interesting account of recognition. Not only Hegel, but people who talk about Hegel. And one very interesting discussion of Hegel's work in this area is offered by Alexander Kojève, who manages to really expose and bring out the more critical Marxist aspects of especially young Hegel. So anyway, I won't go into detail into this idea, but recognition for Hegel is at the core of human being, is our deepest desire is our desire to be recognized. Right? However, recognition is necessarily intersubjective. It is necessarily dependent on others. So you can only really be recognized by someone who you fully recognize. Right? So you cannot be recognized without recognizing. So there is this deep aspect in recognition. Recognition is necessarily mutual recognition. Right? And that's precisely what's not happening in criminal law. Right? So how is it that liberal theorists manage to talk about this idea of recognition, equality, autonomy in criminal law? Well, there are, if you look at Hegel's work especially, and try to use it as an interesting way of thinking about law in itself, I guess we can say that there are three ways in which recognition can be seen to exist in this process, in this framework. One is as an assumption. I think that's the main place of recognition in liberal theory especially. We assume we're all equal. We assume our communities already provide us with everything we need for mutual recognition. So we're citizens, so therefore a crime is the only thing, or the main thing, that disrupts what would otherwise be a very completely fulfilling environment where we can all recognize each other as full members of the community. And that's obviously a fantasy. Hegel himself in his later work, even though he really tries to assume, he says the modern state, the basis of the modern state is basically a state in which there is mutual recognition as an objective reality, but he himself in his philosophy of right cannot help but hint in several points that this is actually, it's an assumption, it's a fantasy, it's an illusion that we need to maintain for the modern state to exist. Because it says, for instance, the very existence of poverty denies this mutual recognition. Justice, especially in the international sphere, cannot help but become victor's justice. So there are all these different elements in our current society that kind of hint at us that this assumption is an assumption. The other point, which is where I guess many liberal theorists that try, like Duff, I imagine, who tries to be a bit more, I'd say, sensitive to the context or to the social reality of crime and punishment, I guess posit recognition as an aspiration. So the criminal law acts as if like we need to reach out to recognition, and we need to create a criminal law that tries to foster recognition. And I guess, for instance, Peter Ramsey, when he talks about the presumption of innocence, he says that, well, the presumption of innocence, what it actually does is that it enforces a burden of trust on people. So he says basically by enacting the presumption of innocence, we act as if we can trust the criminal. And obviously, this is in itself entirely problematic as well, especially if we want to really try to put that in practice. So if we act as if we trust, we are already assuming we don't really trust that person. We can't really trust. There's not really mutual recognition either. The thicker account, part of Hegel's account of recognition, is that recognition is a process. Right? It is an ongoing process in social reality. Right? He said it's a struggle. Especially Axel Honneth and Kojève talk about it very clearly. There is a struggle for recognition in society. Right? And interestingly, the main conclusion that we take from especially Kojève's account, Hegel's account as well, is that recognition is a process that most of the time, or especially throughout history and in social settings, a process that goes wrong. Right? So in our struggle for recognition, we arrive at situations of unequal, broken recognition, what he calls the master-slave relation, right? The master-slave dialectic. Right? So we arrive at a situation in which one person basically concedes the struggle, one part concedes the struggle and becomes a slave, a bondsman, to the other person who wins the struggle and becomes the master. And Hegel says, well, but that's not really good. This is not recognition. It's not satisfying. And interestingly, the first thing that comes in our head is that, well, obviously it's not satisfying because one of the parties is not really recognized. But for me, the full thrust of Hegel's argument is that none of the parties is recognized. What the master receives is nothing. It's an illusion. It's an illusion of power. It's not really recognition, because it doesn't fully recognize the other party. So he's never fully recognized in return. Right? But is a deeply problematic form of recognition, because, as I say, it concedes social relation, because it concedes power, the power to dictate the social setting, the social relation between the two parties. At the same time, so there is, I guess, this strong motivation for the master to preserve this relation, believing that this relation there is advantages to the master, but that nevertheless is never fully satisfying and never really reaches any of the true ideals that we seek in our human condition. That's why Kojève especially would talk that, well, the slave is the one that actually has the potential to overcome his or her condition, and so there's no hope in ever expecting the master to try and reach full recognition. We need to expect the slave to realize. And there's a really fascinating discussion of that, but I won't go into that. Right. So what we can really see happening in criminal law and punishment is exactly this situation of broken recognition. Right? The punisher, the criminal justice system, acts as the master who dictates the terms of communication, believes that they are setting a standard of justice, but in fact all that they're doing is perpetuating a situation of broken recognition. See, perpetuating the struggle, basically. And it's self-defeating in itself. So, well, I guess there's terrorism in the title of my paper, and I haven't talked about it yet. But so why is terrorism interesting to this discussion? Well, basically, if we go back to accounts of communication such as Duff's, for instance, the terrorist has a very interesting place there, because when Duff says, well, the criminal justice process has to be criminal law has to be a communicative endeavor where we treat each other as members of a community, etc. He then goes on to consider, well, whether or not this idea of community has limits. So does it mean that we have a duty to treat everyone as a member of that community? And he says, well, there are certain situations that can put this idea of community to the limit. And the main one is the idea of the terrorist. Because it says, well, the terrorist really, the very idea of terrorism is that they're not trying to communicate with us. They're trying to destroy everything that our community represents. So the terrorists can really put this idea of this dialogic logic, this communicative logic to the test. And interestingly, he considers whether or not the criminal law should treat the terrorist as a citizen, as a criminal, which for him is a member of the community, or if we should treat the terrorist as something else, as an enemy, for instance. In my paper, I analyzed 2 articles by Anthony Duff, which are 3 years apart. And interestingly, in the first one, he's very reluctant. He said, no, we can't really do this. We have to really uphold our principles, and this idea of putting anybody, even a terrorist, in this different relation is deeply problematic. But then 3 years later, he arrives at a really different conclusion. He adds a third, so to speak, a third possibility there, which is to treat the terrorist as an unlawful combatant, as in the US, which is basically not even an enemy. It's just a person who has no rights and can be just thrown in Guantanamo and forgotten about. And then he says, well, that's really wrong. But an enemy combatant they have rights under international law. So maybe he's more reluctant to accept that the terrorist, in other words, can be regarded as a citizen, right? But in what I try to say about this is that if my intuition is correct, that actually every criminal law is in essence already treating its subject as an enemy, or at least as a potential enemy, terrorism doesn't represent the limits of this communicative idea in criminal law. Actually, what terrorism really does is expose everything that's problematic with criminal law in the first place. It fully exposes the underlying logic of every process of criminalization. It just throws it out in the open. Right? It throws it out in the open, that the idea that the notion of community upheld by criminal law is severely limited, is severely unequal, exclusionary, and deeply problematic. Right? So, if we really want to be communicative with in our relations with others, we need to seek a very different approach to problems such as crime and terrorism. And this maybe includes or involves even rethinking our own ideas of what crime really is, or what terrorism really is. And I won't go into detail now. How much time?
2 more minutes.
2 more minutes, okay. Yeah, so I won't go. So what I'm trying to develop now that I've got back to it, is that, well, last year, 2 years ago, we had a really interesting panel in Critical Realism Conference about law that Alan organized. And in that I started thinking about love, or rather loving, from the work, through the work of Eric Fromm. And he makes a fantastic critique of love, as in the Western way of thinking about love, as deeply problematic. And he tries to come up with a fuller account of love, which he says that, in which he conceives love as an action. Which he doesn't actually talk about it, but I got a very interesting comment in my presentation at the conference, saying he contrasts, in essence, love with loving. So love should never be an object. Love is an activity. And for me, I start more and more to realize that this thicker notion of loving is at the core of what a proper process of perhaps an inclusionary process of recognition should be about. Right? And his account of loving is very interesting. It is fantastically rich and has very interesting details, and I'm happy to talk about that afterwards, but I think I perhaps should just stop here.
Well, I just wanted to say first of all, it's been a